It's the ABCs of environmental law, and today C stands for Chevron Deference. Now, this is a legal doctrine, and for 40 years, it was basically the foundation, the secret sauce for environmental regulation. But in 2024, that recipe changed. The Chevron doctrine comes to us out of a U.S. Supreme Court case, Chevron versus NRDC. And in that case, the court recognized that if a law was vague, courts would defer to technical experts at agencies like EPA. And the logic is simple. Judges are experts in law, but EPA and other agency scientists are expert in their field. This is what they do all day, every day, and maybe they know more about the science than a court looking at it for the first time does. So if the science was sound, courts assumed that the agencies were in a better position to know what the state of science was. So the agency's interpretation usually won. It got more weight than not. But the Supreme Court's recent ruling in Loper Bright Enterprises versus Raimondo effectively ended Chevron deference. The courts ruled that judges should no longer defer to an agency's interpretation just because a law is ambiguous. Now, that's the court's job, not scientists. And this is a massive shift that makes it easier for people and companies to challenge environmental regulations in federal court. The lawyer's secret for those of us in the Golden State, though, is that while Chevron is dead at the federal level, California is a different story. No surprise, right? Under a doctrine known as Yamaha, California courts still give great weight and considerable deference to state agencies like the Air Resources Board or the water boards when they're interpreting complex regulations. So, while federal environmental rules are facing a new era of uncertainty, California's state-level Chevron Light approach through Yamaha keeps our environmental agencies on firmer legal ground. And understanding this gap between federal and state power is also the key to knowing where environmental law is headed next.